All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Are you looking for an inexpensive yet quick way to settle small money claims legitimately, but you hesitate to consult a lawyer? There's a way to do this in the Philippines. You can file what is called a small claims case. Introduced by the Supreme Court of the Philippines in 2008, the Small Claims Court project was pilot tested in select trial courts for 2 years as a simplified way for litigants to pursue claims amounting to 100,000 pesos or less. This 2-year pilot test led to the court's promulgation on March 18, 2010 of the Rules of Procedure for Small Claims Cases, which took effect in all first-level courts nationwide. Since then, the Supreme Court has steadily expanded the rule's reach by periodically raising the jurisdictional amounts and amending its procedural requirements to reflect real-world needs, with the latest amendment in the jurisdictional threshold taking effect in 2022. What exactly are considered small claims cases, and what is the procedure in pursuing and settling them? How can understanding the process of settling small claims empower ordinary Filipinos to trust our courts by giving them access to efficient justice? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 5th of December 2025, and today we talk about the simplified and expedited process of resolving specific civil disputes under the Rule on Small Claims as provided in Administrative Matter number 08-8-7-SC. And joining us today to discuss this is Judge Jackie B. Crisologo Sagisag, Presiding Judge of Branch 67, Metropolitan Trial Court of Makati City. Judge Jackie is a member of the Remedial Law Department of the Philippine Judicial Academy and of the Technical Working Group for the Revision of the Rules on Summary Procedure and Small Claims Cases. Hi, Judge Jackie. Welcome back to the Supreme Court Podcast.
Hi, Attorney Mike. Good day again to everyone. Thank you for having me.
All right. It's always a pleasure to have you with us, Judge Jackie. First off, what prompted the Supreme Court to come up with the rules on small claims cases? Can you give us and our listeners as well a brief background on why the court promulgated this rule?
Well, the Supreme Court has always been focused on access to justice and the speedy disposition of cases. So I believe the court had these in mind when it promulgated the rule. If we look at Section 2, Rule 4 of the Rules on Expedited Procedures, that is the specific rule right now for small claims cases, the objectives are enumerated there. First, to protect and advance the constitutional right of persons to a speedy disposition of cases. Second, to provide a simplified and inexpensive procedure for the disposition of small claims cases. And third, to introduce innovations and best practices for the benefit of the underprivileged. In short, the goal for the courts is to have a simplified, cost-effective, and a more efficient system, and as well to ensure that justice is more accessible to ordinary citizens.
And I remember a striking feature of this small claims cases rule when it was first introduced is that you don't need a lawyer to go to court.
Yes, that's right. The parties appear and represent themselves in court.
What's the logic why lawyers are not allowed to appear for parties in small claims hearings?
So, yes, lawyers are not allowed to appear during the hearing for small claims cases. The reason for this is twofold. First, to provide an atmosphere that is more conducive for settlement, because small claims cases, really, the primary goal of the judge here is to encourage the parties to settle. That's why we ask them to face each other in court without the assistance of lawyers and without being burdened by the technicalities. They are encouraged to negotiate. So that's the first one. And then, of course, to reduce cost.
Yes.
You don't have to pay lawyers' fees and appearance fees.
Single appearance
all
fee
of that.
could be as much as
Correct.
the amount you're claiming.
Correct. That's right. That's right.
So what kind of everyday disputes can be brought to a small claims court? And which courts are authorized to hear small claims cases?
Okay, a small claim is defined under the rule as an action that is purely civil in nature, where the claim or relief is solely for the payment or reimbursement of a sum of money. It does not include actions where there are other claims or reliefs aside from payment or reimbursement, or actions that are coupled with provisional remedies. So the claim or demand may be for money owed under a contract of lease, contract of loan, and other credit accommodations. What are credit accommodations? For example, credit card transactions. We also have contract of services or contract of sale of personal property. For sale of personal property, the claim should not include recovery unless it is made the subject of a compromise agreement between the parties. Also included are actions for the enforcement of barangay amicable settlement agreements and arbitration awards. The first level courts, these are the metropolitan trial courts, the municipal trial courts in cities, the municipal trial courts, and the municipal circuit trial courts have jurisdiction over small claims cases.
I understand there's a jurisdictional amount for small claims cases, Judge Jackie. And I remember it started with 100,000. So what is it now?
So the current threshold amount for small claims is 1 million pesos. When the first version of the rule was promulgated way back in 2010, the amount was 100,000. In 2016, because the rule was found to be effective, the Supreme Court wanted to expand the coverage. We introduced amendments and increased the amount to 200,000 pesos. And then in 2019, again, the threshold amount was increased to 400,000 for the metropolitan trial courts and 300,000 for other first-level courts. So there used to be a distinction between the threshold amounts for metropolitan trial courts and other first-level courts. But now, finally, in 2022, with the rules on expedited procedures, the amount is 1 million pesos. This is for all first-level courts without distinction. The money claim must not exceed 1 million exclusive of interests and costs.
And just to distinguish this, Judge Jackie, from the rule which we discussed last week, the rule on summary procedure, are there also differences in terms of jurisdictional amount? And how do you actually distinguish the rule on small claims from the rule on summary procedure?
Well, first of all, the nature of action is different. As I mentioned earlier, for small claims cases, it has to be purely for payment or reimbursement. Other than that, even if it's payment or reimbursement, but there's a provisional remedy, that would not fall under the rule on small claims. That would be for rule on summary procedure. And then for the rule on summary procedure, the threshold amount is 2 million pesos. Okay, so for actions for payment or reimbursement exceeding 1 million, automatically that would be under the rule on summary procedure. And then, of course, we have forcible entry and unlawful detainer, which we discussed last time. And then damages. It used to be that liquidated damages was an action included under the small claims rule. But the Supreme Court decided to exclude that from coverage, and that would fall under rule on summary procedure instead. Because we realized from feedback from the judges that damages, it's not as simple as the payment or straight out reimbursement action. So that's been excluded now from the small claims.
So what happens if you're asking for damages, automatically it will be under a summary
procedure up to 2 million for
There's
the first
no
level
way to
courts.
separate that from the money claim, right?
No,
it's complicated.
No. It's complicated, yes. That's right.
And talk about filing fees, Judge Jackie. That is often a hindrance to people from seeking justice. So how affordable are small claims fees? And are there situations or exceptions where litigant can ask the court to waive these fees?
Well, the general rule is to pay the filing fees, which is the same rate as in regular cases. But a party may file a motion to sue as an indigent, and this motion will be referred to and resolved by the executive judge in multi-sala courts. So under Rule 141, an indigent litigant is one whose gross income and that of their immediate family do not exceed an amount double the monthly minimum wage of an employee, and who do not own real property with a fair market value as stated in the current tax declaration of more than 300,000 pesos. So if the party qualifies, then he or she shall be exempt from paying the filing fees. But we must remember that that exemption does not include the sheriff's trust fund. That has to be paid.
Okay,
that has to be paid.
And
Yeah, regardless.
around how much is this?
1,000 pesos.
1,000 pesos. Okay. And many people whose cases fall under the rules on small claims are not even sure if they need to go to court in person. Should they, and what should they expect when they go to a hearing?
Yes, the parties, they have to appear.
Right.
It is really important for the parties to personally appear during the small claims hearing, because they will have a chance now to face each other and to negotiate a settlement, as I mentioned earlier. Usually the money claims are for loans and credit transactions, credit cards. And during the hearing, they can negotiate on the penalties, the interest rates, and lower all of these rates. While if the defendant fails to appear and summons was duly served upon him or her, then the court will immediately render a decision based on the statement of claim.
I see. And what do they need to bring? Like, which documents do they need when they go to a small claims court?
Well, all the information and the template forms needed by the parties are in the Supreme Court website actually. That's sc.judiciary.gov.ph. So the plaintiff here needs to file a statement of claim. We call it a statement of claim that takes the place of the complaint.
All right.
In other civil cases. Meanwhile, the defendant files a response that would be the answer in other regular civil cases. Of course, the parties will have to attach any evidence that would support their respective claims, affidavits or receipts, whatever documentary or other evidence that they have. And then the website also has all the sample motions. We talked about the motion to sue as indigent. It's also there. If the parties do not have access to internet, then they can proceed to the office of the clerk of court where they are situated. They ask assistance from the office of the clerk of court, and that office is supposed to offer them whatever assistance they need in relation to small claims cases.
And when they go to the clerk of court, judge, they can just get the form and they can fill it out by hand, the forms.
Oh yes, the template forms here are user friendly. We have tick boxes. They can just fill in the blanks. And then they are in English, but we also have translation Tagalog and Visayan right now. And the court personnel are also mandated to be proactive in small claims cases. It's in the rule, section 16, mandating that the clerk of court and other court personnel should assist the parties in all stages of the proceedings. So the court here plays a proactive role in helping the parties not only with the forms but also providing them information about coverage, requirements, and the procedure itself. Even the judges themselves are also tasked to explain the nature of small claims hearings at the beginning of the small claims hearings, and they are mandated to exert efforts to bring the parties to an amicable settlement.
And how long does the whole process take, Judge Jackie, including the issuance of the decision? Can you walk us through the small claims timeline?
All right. So once a statement of claim is filed, the court issues summons within 24 hours. And then the sheriff should serve it upon the defendant within 10 days. The hearing, in the notice of hearing that accompanies the summons, the hearing must be scheduled within 30 calendar days from filing of the statement of claim, or if the defendant resides or holds business outside of the judicial region, within 60 calendar days. So that's just 2 months, 2 to 3 months, right? And during the hearing, first of all, postponements are not allowed, except for physical inability. Postponements are not allowed. So there's only one hearing, and whatever happens during that hearing, the court has to render a decision. So for example, if the parties appear and submit a compromise agreement, then the court will immediately render judgment based on the terms and conditions of that agreement. If there is no settlement, judgment rendered within 24 hours. If the defendant does not appear, the same thing, judgment rendered within 24 hours.
If they're in the process of negotiating, would that be a venue to finally nail down the settlement, or are they given time to finalize the settlement?
No, we cannot reset the hearing because of negotiations.
Right.
So we ask them to close the deal. Yeah, close the negotiation during that one-day hearing. So what we usually do, we give them time. Like, we give them a second call.
Right.
So we tell them, you talk about it and finalize the terms and conditions today, so that the court can decide it right away.
And I can imagine this is very helpful, especially if you're in a court with a huge docket. If you can
Very
dispose
helpful.
of at least a few cases every 2 months, that would speed up the disposition
Yes,
rate.
very helpful. And with the expanded coverage of the rule on small claims now, then a bulk of our cases in the first level courts are covered under this rule. And so our disposition rate is much quicker.
And this is not appealable. It's immediately executory.
Yes,
So you don't
correct.
plug the appellate
The
court
RTCs.
or the
That's
RTCs.
right. That's right. That's right.
Okay, interesting. And when a party wins a small claims case, how do they actually collect the money awarded to them? What happens if the losing party still refuses to pay? So what remedies does the court provide in such cases?
So it's the same thing as in ordinary civil cases. The winning party files a motion for execution. But in small claims cases, when the decision is rendered and proof of receipt is on record, execution shall issue upon ex parte motion of the winning party. But if a decision is based on compromise, proof of receipt is not even required, and the motion may immediately be filed by the winning party.
And Judge Jackie, I know you mentioned this already, but just to emphasize the importance of attending that single hearing, what happens if it's the complainant who does not appear, second, if it's the defendant who does not show up during that hearing?
Okay. So if the plaintiff fails to appear, the statement of claim will be dismissed. All right. If the defendant fails to appear, then he or she loses the opportunity to negotiate a settlement with the plaintiff. In that scenario, the court simply decides the case as warranted by the facts stated in the statement of claim. So we really do encourage the parties to come and personally appear before the court for the small claims hearing.
All right, that's a good reminder, Judge Jackie. So lastly, what's our key takeaway from our discussion today?
Well, the key takeaway is that the Supreme Court is committed to ensuring that everyone has access to justice. The rule on small claims, which was introduced over 10 years ago, shows this dedication by making it easier for parties to resolve their disputes. By allowing the litigants to represent themselves, the judicial process becomes simpler and more cost-effective. I use this term repeatedly, but I think it's very important. Now, how there is still a common misconception that justice is only for the rich and that it is always delayed. But with the rule on small claims, the court hopes that the public will start believing otherwise.
Right, and we hope so too. So thank you so much again, Judge Jackie, for joining us for the past 2 podcasts.
Thank you very much, Attorney Mike. Thank you to the Public Information Office for having me.
And if you wish to read the full text of the rules of procedure for small claims cases, as well as download the pertinent small claims forms, please visit the Supreme Court website at sc.judiciary.gov.ph/small-claims. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court, through the Ponencia of Associate Justice Ami Lazaro Javier, has unanimously ordered the return of the 60 billion peso PhilHealth funds previously transferred to the National Treasury and permanently prohibited the transfer of the remaining 29.9 billion peso fund balance. The court, by a majority vote, also declared void Special Provision 1, Paragraph D, Chapter 43 of the 2024 General Appropriations Act, or GAA, and Department of Finance Circular Number 003-2024 for having been issued and implemented with grave abuse of discretion, amounting to lack or excess of jurisdiction. Special Provision 1, Paragraph D, which authorized the return of the fund balance or the excess reserve funds of government-owned or controlled corporations, or GOCCs, to the National Treasury to fund unprogrammed appropriations under the 2024 GAA, is declared a rider for not being germane to the purpose of the law. The SC also ruled that Special Provision 1, Paragraph D is unconstitutional because it impliedly repeals Section 11 of the Universal Healthcare Act, or UHCA, and the sin tax laws. Under Section 11 of the UHCA, PhilHealth is required to maintain reserve funds up to a ceiling equivalent to 2 years of projected program expenses. Each year, PhilHealth must set aside part of its net income as reserve funds, and any unused funds must be invested so that earnings are added back to these reserves. The SC ordered that the remitted 60 billion peso funds be returned to PhilHealth through the 2026 GAA. The Supreme Court en banc on Wednesday, December 3, 2025, declared that votes for nuisance candidates whose certificates of candidacy are cancelled or not given due course are considered stray votes and shall not be counted in favor of any other candidate. The decision, penned by Associate Justice Maria Filomena Singh, sets a new rule under the automated elections, departing from its previous rulings for manual elections, where vague votes are counted in favor of the legitimate candidate. Emphasizing that the previous rule had no basis in law, the court said that a nuisance candidate is deemed to have never filed a certificate of candidacy. The decision was in connection with a petition filed by Marcos Macoy Amutan, who was initially proclaimed as a board member of the Sangguniang Panlalawigan for the 5th District of Cavite in the 2022 elections. His proclamation was annulled when a losing candidate was declared a nuisance candidate and his votes were credited to another candidate. The Supreme Court reversed the annulment of his proclamation. The Supreme Court en banc, during its session on December 3, 2025, granted the manifestation with entry of appearance filed by the Office of the Solicitor General, or OSG, allowing the OSG to resume its role as counsel for the respondents in the case. This is in connection with a petition filed by former President Rodrigo Roa Duterte and Senator Ronald Bato de la Rosa challenging Duterte's arrest and the Philippine government's cooperation with the International Criminal Court. The OSG had earlier asked to be excused from representing the respondents, which the Supreme Court granted on April 2, 2025. But the OSG on December 1 informed the court that it was again entering its appearance as counsel for the respondents and requested copies of all court issuances related to the case. The Supreme Court en banc has approved the rules on Filipino Sign Language Interpreting in the Judiciary, or FSL rules, implementing Republic Act No. 11106 or the Filipino Sign Language Act. The FSL rules is formulated to guarantee deaf Filipinos equal, relevant, and effective access to justice. It shall apply in all court proceedings in cases involving deaf Filipinos to ensure their participation at any litigation stage and to grant them the right to choose their preferred mode of communication. The FSL rules was drafted by the Technical Working Group headed by SC Associate Justice Chapar de Maampawas Chairperson and Associate Justice Jose Mayras Marquez as Vice Chairperson. The rules shall take effect on December 15, 2025, following its publication in 2 newspapers of general circulation on November 29, 2025, and on the Supreme Court website. Meanwhile, the Office of the 2025 Bar Examinations Chairperson, Associate Justice Ami Lazaro Javier, has announced that the results of the 2025 bar will be released on January 7, 2026. The oath-taking and roll-signing ceremonies of successful bar examinees will be held on February 6, 2026. Meanwhile, the Office of the 2026 Sharia Special Bar Examinations, or SSBE Chairperson, Associate Justice Henry John Paul Inting, has announced the opening of the application for the 2026 SSBE until December 12, 2025. Information may be found at the Sharia Special Bar Bulletin No. 2, including application fees and payment details. Justice Inting encouraged aspiring Sharia counselors at law to prepare diligently, to trust in themselves, and to step forward with courage and conviction. On December 5, Chief Justice Alexander Hismundo led the Supreme Court's annual Christmas celebration. Emphasizing that Christmas is a season of hope, he expressed that he looks toward the new year with great hope and confidence that the SC community will carry the judiciary forward with renewed strength and unwavering dedication. He reflected on his tenure as Chief Justice for the past 5 years, this Christmas being his last as the head of the judiciary in view of his retirement in November 2026. Themed Paskong Makabago, Hudikaturang Makatao, this year's celebration included a chorale competition, performances by special guests, a decor contest, and a raffle. On December 2, 2025, members of the Sabah Law Society, or SLS, led by its president, Datuk Jan Sikayun, paid a courtesy call to Associate Justices Rodil Zalameda, Jose Mayras Marquez, and Raul Villanueva at the Supreme Court in Manila. Justice Zalameda and Justice Villanueva led the discussions on the similarities and differences in the hierarchy of courts, selection and appointment of judges, and Sharia courts in Malaysia and the Philippines. Also present were Deputy Clerk of Court and Chief Technology Officer Attorney Sherwin Uy, who gave updates on the digitalization of the Sharia bar examinations, and Integrated Bar of the Philippines, or IBP National President Alan Panolong, who shared that the visit is a prelude to the country's hosting of the ASEAN Bar Leaders Council Summit next year. Justice Marquez thanked the SLS and the IBP for visiting the SC, saying the SC looks forward to opportunities for collaboration. SLS is a statutory body empowered to regulate legal practice in Sabah, Malaysia. Meanwhile, on Monday, the Supreme Court, through the Committee on Gender Responsiveness in the Judiciary, or CGRJ, joined the commemoration of World AIDS Day by conducting an outreach activity at Duyan Center in Manila, a shelter for children living with HIV. The CGRJ is co-chaired by Associate Justices Henry John Paul Inting, Josep Lopez, and Maria Filomena Singh. The Duyan program under Project Red Ribbon aims to provide care and support to children living with HIV in the Philippines. You are now up to date with the Philippine Supreme Court. I am Tifat Andido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast as well as previous episodes on the Supreme Court Public Information Office's accounts on Facebook, YouTube, Spotify, and Apple Podcast. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Mike Navalio as overall in charge of production, Attorney Karen Martinez as supervising producer, Jay Rempilio, executive producer, Tiff Atendido Beltran, producer, May Sibal, Attorney Ian Aldueso, Attorney Sheila Reyes, and Ramir Simbahon as researchers and writers, Brian Austria, Don Ryan Balza, and Vini Laranio as audio editors, Lawrence Olanyo and Austin Aliscat as video editors, Bea Batong as graphic artist, and Tyke Flores and Jerome Batumalaki as web editors.